Okay, today we're on the second part of our OTP. We are starting with clause 8. I did last week or the previous session, I did start on clause 8, but I would like to just go back to it just to refresh our where we are. Just go here, it's clause 8. It's where we talk about the second property. Now, the second property is called subject to property as well in a lot of people's jargon. Okay, this agreement is subject to and conditional upon the sale of the purchaser's property as set out in paragraph 1.13. This condition exists for the benefit of the purchaser who may unilaterally waive compliance herewith in writing. Now, unilaterally means one-sided. So he from his side can waive the condition. The seller can't waive it on his behalf or for him. It's specifically recorded that this suspensive condition shall not to be regarded as being fulfilled until all suspensive conditions to which the sale of the second property is in turn subject to are fulfilled. Okay, so your second property is your subject to property. I buy from tenants, I buy from tenants, but I sell to Annalie, but an Annalie's property, my sale to Annalie hasn't been secured yet. It will only be fulfilled once my deal with Annalie is secured. All the conditions are fulfilled and the bonds approved. The purchaser undertakes that the transfer of the second property will take place simultaneously with or prior to the transfer of the property, and that he will not accept an offer which is subject to the sale of the third property. Now, this is, I think I told you last time, this is just to make sure that the chain doesn't get too long. It doesn't mean you're not allowed to ever do this. If there is a situation that this comes into being, just do an addendum, make sure that all the parties know that there's another property in the chain and that the chain goes on and on. I once had a situation where 6 transactions were linked and the last one actually fell through, so all 6 fell through. So I understand why they have this in the deal, in our OTP, but it doesn't mean that you have to do that. You can fix this. In the event that the suspensive condition as set out in paragraph 8.1 above has not been fulfilled within the time to the seller in writing, then this agreement shall automatically fail and be of no further force and effect. And the parties will use their respective best endeavors to restore the status quo ante. That means to go back to original state, and all amounts paid by the purchaser in terms of the agreement on account of the purchase price will be refundable to him, including an interest which may have accrued. Okay, so obviously, if it doesn't happen, if the suspensive conditions aren't fulfilled, it becomes null and void, the contract. Now, 8.4 is the one I asked you to have a look at. But before I carry on, I would like to explain this whole clause to you by means of a sketch that I've got. But before I do that, make sure that you understand this is only pertaining to a second offer. Or it's not pertaining a 72-hour clause in our contract. Doesn't mean that another offer can come in and with a bond. It doesn't pertain to a bond. It's only applicable where there's a second property. If you have an agent that says, or a seller that says, but whoever comes first, and if he gets another offer, he wants the 72-hour clause to come into effect, and he refers to a bond, then you will have to do an addendum, because our offer is only, the 72-hour clause is only applicable to a second property. They talk about the 72-hour clause. So the easiest way to explain this is to say, this is your property, this is your subject property. This is the one that I'm going to be buying from tenants. I buy one, but when I buy from tenants, my offer to purchase is subject to the sale of my own property, and this is where the backdoor clause in 8.4 comes into effect. So I'm buying from tenants and I'm still selling the smaller house, which looks similar to that, just without the extra windows at the top. Now, we all know that that's fine. In the interim, while we still, remember in our clause 4, we also say that we can continue marketing. So in the interim, you can still continue marketing this property because this one has a condition that hasn't been fulfilled. So along comes a buyer 2. Annalie also wants to buy Tennis's house. So she's actually competing with me now. There she's buyer 2. Once her bond is approved or she pays her cash, and all her conditions are fulfilled. So the moment she's done that, then the seller can put me buyer 1 on terms for 72 hours to either equal this or fulfill my conditions or waive it. So that is the 72-hour clause in very easy language. So I buy from that one, I still have to sell there. In the interim, he gets another offer, which he accepts. We put me on terms, but only after all the conditions have been fulfilled. And at this stage, a copy of the competing OTP has to be provided as well, and also proof that the conditions are met before we get the seller to put us on terms. So I'll say this to you. It's just an easy way to explain it. I'm going to read it now. It will make more sense. The seller may continue to market the property until the suspensive condition relating to the sale of the second property has been fulfilled. That means the property that I'm still selling. Should the seller during this time receive an unconditional offer to purchase for the property, that's what they call the competing offer, he will have the right to call upon the purchaser by notice in writing to waive the suspensive condition contained in paragraph 8.1, thereby making the sale unconditional. Now, a competing offer can be cash or it can be subject to a bond, but then it only becomes a valid competing offer if the bond is approved. Okay, thereby making the sale unconditional within 72 hours after delivery of such notice to the purchaser or such extended period as the seller in his sole discretion may allow. That's what they call the waiver period. Such notice shall include a copy of the competing offer. If the purchaser fails to fulfill or waive his rights in writing within the waiver period, the seller shall be entitled but not obliged to accept the competing offer. The seller shall notify the purchaser of his decision in writing within 3 days, at which time, should he accept the competing offer, this sale shall lapse and be null and void. Should the seller elect not to accept the competing offer, this agreement shall remain in full force and effect. Okay, there's also an addendum that you can draft, and when it gets to the situation, it's under our addendums. I'm not going to discuss the addendum now, but there is an addendum as well, where it helps you with the wording for this. As long as you understand how it works and you understand that this does not pertain to a bond approval, it's only to a second property. Possession and risk. Possession of the property, all risk and benefits of ownership shall pass to the purchaser on the date of registration of transfer, from which the purchaser is liable for the payment of rates, taxes, and levies. The seller indemnifies the purchaser from any claim that may be instituted against the purchaser by any relevant authority for arrear rates, taxes, services that may be owing to such authority in respect of the property. The purchaser reserves the right to take recourse against the seller in the event that any authority should institute action against the purchaser for alleged arrear rates, taxes, services owed by the seller. It's important that the seller knows this, that you explain to them that the transfer can't take place unless all their accounts have been settled. So, and the purchaser doesn't assume liability for it. Should occupation be given or taken prior to registration, all risks and benefit of ownership, excluding liability for payment of rates and taxes, insurance and levies related to ownership of the property, shall pass to the purchaser from date of occupation. In such a case, the purchaser undertakes to maintain the property, fixtures and fittings in the same good condition and working order from date of occupation to date of transfer. Now, I would, in this instance, take photographs. Take photographs of the property to make sure that it's all done on notice slip, but make sure that you have proof of what the property looked like. So if anything goes wrong, that and the buyer has to move out for some other reason, that it will be in the same condition. And this is also then, remember, we spoke about it the previous session. Please remember that the buyer cannot do any alterations to the property. certificates. Now, this varies from province to province, but the electrical compliance certificate is always necessary for the seller. It's important that you also inform you about this when you do listing. Gas, if there's gas installed, the entomologist is only for KwaZulu-Natal and Eastern and Western Cape. Okay, this is for sectional titles, and electrical fence compliance certificate is needed, and the body corporate and or managing agents normally supply that. And then the water compliance is necessary in Cape Town, in some places in Western Cape. We don't see this in Gauteng. The seller warrants that no additions or alterations will be made to any of the electrical, gas installation or plumbing installation on the property after the issue of the relevant certificates and prior to occupation by the purchaser, or date of registration of transfer, whichever is earlier. Should the seller fail to furnish the purchaser with the required certificates timelessly, the purchaser shall be entitled to obtain same, and the seller, by pending his signature hereto, authorizes the conveyancer to reimburse the purchaser by deducting the cost thereof from the proceeds of the sale. So the seller is liable for it, but let's say the seller says he doesn't have the money, and the buyer can pay for it, have it done, and he gets reimbursed at the end of the transaction on the full, and when the attorney does the finance. We are quite often see this, but that's normally when the seller really doesn't have any money. Okay, foot stewards. Foot stewards hasn't fallen away. Remember, our contract doesn't fall under the CPA unless the seller does it in his ordinary course of business. I'm going to send you a document or an article about this separately. I'm not going to discuss it in full today because that's a CPA. But I'm going to send you an article about this, so should anybody not understand how it works. But remember that foot steward still applies because our contract doesn't fall under the CPA unless the seller is doing it in his ordinary course of his business, if he's an investor or a speculant or a developer. The property is sold to foot stewards as it stands, at date of the signature hereof, together with all buildings, fixtures, and fittings thereon. The seller is therefore not liable to the purchaser for any defects in the property, whether visible or not, so that's latent and patent, unless the seller knew of material defects that are not visible and did not bring them to the attention of the purchaser, Annexure A. That is where our Annexure A comes in. Yesterday, when you saw on the Lightstone Zoom session with, they were very clear about this, that when you do a mandate, you must also fill in your mandatory disclosure form, and this is our Annexure A. Very important. It's also very important to make sure that this is done correctly. You're not allowed to fill it in. It must be done by the seller, because and if the seller is overseas, I said yesterday, then you must get an inspection company to do it for them, because the moment you put your handwriting in there, then you become liable. Neither the seller nor Property.CoZa shall be obliged to point out the boundaries of the property or survey beacons, and shall not be responsible for any deficiency in the extent of the property or be entitled to the benefit of any excess. Neither shall either party be liable for the correctness of the advertisement of the property or the square meterage of the stand or the buildings erected thereon. This is very clear, and I can tell you about a couple of times that a contract nearly fell through because of this. In Dainfern, for instance, we had one where the agent put in the wrong square meterage on the size of the land, because it was 1 square meter out. He used the cadastral square meterage, not the registered. And the client tried to use that to get out of the deal. Fortunately, we came back to the offer to purchase, and it says there, the square meterage of the stand or the building is erected thereon is more or less. So we could actually save the deal by pointing out 11.2 that we did actually cover ourselves there. It's also the extent of the property, but it's always professional to be able to show people the boundaries. But on farms, for instance, it's almost impossible. In Nelspruit, I was selling farms in my early days, and we had a boundary which was on the top of a copy and was actually mentioned in the deeds office. The boundary was 2 white stones under a tree. Now, there was no ways I was going to climb up that copy with all those snakes to go and look where it is. So I just sent the clients up. But I don't have to be, you don't have to show them the extent or the boundaries, but on a normal house in town, obviously it's all fenced and it's easy. Warranties and undertakings. The seller declares that he is not selling the property in the ordinary course of business and that the seller is therefore not a supplier as defined in the terms of CPA. The CPA is therefore not applicable as far as the sale of the property is concerned, and therefore no cooling off period as envisaged by the CPA applies. Now, this is a total session by itself on the CPA and all the regulations around that, but our contract does not fall under it. So you must point this out to your sellers who actually think, or your buyers think that there's a cooling off period, because there isn't, unless it's a speculant or a developer or investor. But then there are other things that actually come to play, because the cooling off period only kicks in after registration, so that they can't cool off before it's registered. But that's a total different discussion. The seller has given no undertakings or issued any warranties other than what is expressly contained in this agreement. The seller declares that he is a South African resident in the event of the seller being a non-South African resident or failing to provide a valid residence permit to the conveyancers. The seller hereby authorizes conveyancers to withhold such portion of the proceeds of the sale as required in section 335.8 of the income tax. So if their tax is not up to date and they can't provide proof, the conveyancers can hold money back. The parties hereby agree that this agreement constitutes the entire agreement between them, and that no warranties or representatives other than those contained herein have been made by any of the parties or the agent, nor are there any suspensive conditions to the agreement which are not included herein. No variation, waiver, or consensual cancellation of the agreement shall be of any force and effect unless reduced to writing. Now, yesterday, when I had a session with Tinus, I said to him that after a party, the clients can't then have a party, and then the one decides he doesn't want this and he doesn't want that, or they waive things at the party. If it's not valid, it doesn't count at all. It has to be done in writing with both parties signing. So one can't just bump into somebody and then decide to change the conditions. The purchaser warrants that he was not introduced to the property through any estate agency other than Property.CoZa before entering into this deed of sale. He further warrants that Property.CoZa is the effective cause of sale. It's very important, because sometimes you get that the husband went with Pam Golding and the wife came with us, and so that we know that we are clear where our commission is concerned. The purchaser declares that he was granted fair and ample opportunity to inspect the property to his satisfaction, and that he is aware of all conditions and servitudes to which the property is subject to. You don't have to put it out, but he can go and have a look. Okay. So, and also be sure that your client has a look at the property, that you give him enough time to go through the property, to go and check that the stove works, to go and check that the toilet flushes, to go and check everything, because it makes it so much easier, so you don't have problems afterwards. The purchaser and seller warrant that all the material terms of this agreement have been explained to them by the relevant Property.CoZa agent prior to signature. Here it says that you have to explain this. You can't just tell them to just go and read it and send to you. Unless obviously they're overseas, then you must very clearly tell them that they must ask you if they don't understand anything. The seller warrants that there are no illegal occupants or squatters in or on the property. Diane, you'll see that this actually is in here at the end of signing this agreement. So, but obviously in our situation, we discussed yesterday, the day before, we weren't aware that this tenant was going to squat. But here it says that at the point of signing this, that the seller says that there are no illegal occupants or squatters. If there is more than one purchaser, the liability hereunder shall be jointly and severally. This means by themselves and also together, accepting equal responsibility. That is what that clause means. Professional fees. Professional fee, as set out in Annexure C, is included in the purchase price and is payable by the seller to Property.CoZa upon date of registration. The professional fee shall be deemed to have been earned upon signature of this agreement by the parties and for fulfillment of all the suspensive conditions. So they say we've earned it, but we only get paid when registration takes place. This is also why, in some cases, agents take bridging, but they can only take bridging when all the suspensive conditions have been fulfilled and all monies have been paid, because then it's a safe transaction and we've earned our money by them, and then we can bridge with the consent of the principal and then also the sales manager and then the conveyancer. There are different parties, different instances of institutions that offer bridging. Just be careful that you don't get into the habit of doing this, because you never get ahead then. Should this agreement be cancelled as a result of breach on the part of the seller, then the seller acknowledges that he remains liable for payment of the full professional fee to Property.CoZa. We're going to get to the bridging tomorrow. I'm going to start with the bridging tomorrow. The breaching tomorrow, so that we explain to you exactly what breach is. Should this agreement be cancelled as a result of breach on the part of the purchaser, then the purchaser acknowledges that Property.CoZa will suffer damages to the amount of the loss of the professional fee. Accordingly, the purchaser will then be liable for payment of this fee. Should this agreement be cancelled by agreement between seller and purchaser, when the seller and purchaser acknowledge they are jointly and severally liable for payment of the full professional fee, then they have to just share it if they both decide they want to cancel. An act of insolvency or the granting of a provisional or final order of liquidation or sequestration in respect of the seller shall constitute a breach of this agreement by the seller, in which event, should the trustee liquidator of the seller's insolvent estate elect to proceed with the sale, the purchaser shall assume the seller's liability for payment of the professional fee. This is something that you need to point out to them as well. Normally, normal day-to-day transactions, that doesn't happen, but it could. The amount of the professional fee paid by the purchaser to Property.CoZa shall constitute damages suffered by the purchaser as a consequence of the seller's breach, which damages the seller authorizes the purchaser to offset against the purchase price. Okay, so what does that mean? That means that our commission is paid by the purchaser in this case. Okay, because they say that the damages, the seller, that with the damages, the seller offsets it against the purchase price. Any legal costs incurred by Property.CoZa in enforcing its rights to the professional fee against the seller and or the purchaser shall be paid by the defendant on the scale levied between attorney and client. Okay, in the parties, it's not fixed. It will be it's discussed between the attorney and client. Then the parties agrees that Property.CoZa shall affix a sold board to the property for a period of 3 months.